Okay, Mr. Ryan, can you hear me? Can you hear me, Mr. Ryan?
Yes, ma'am, sorry.
Okay. On the record in the matter of the people, the state of Michigan versus Cody Lee Ryan at file number 21-01976. I also have 22-00118. Council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Mr. Ryan, who is present via the Polycom unit.
Thank you. And today was the date that was originally set for a pre-trial and a PA 53 hearing. My understanding is that there has been a plea offered on this.
Yes, Your Honor, that's correct.
You state the offer on the record, please.
Okay. The offer is for Mr. Ryan to plead as charged on this case, 21-01976. The people would have no objection to him being sentenced under 7694A. Mr. Ryan also is to plead on case number 22-00118FY to an added count 2 of stalking, contrary to MCL 7504118, which is a misdemeanor punishable by up to 1 year and or $1,000 and or 5 years of probation. And the people agree not to charge an outstanding warrant request for Mr. Ryan for an additional count of aggravated stalking.
Okay, I have basically guilty to the domestic violence charge in the file number ending in 976 and plead to an added count 2 of stalking in file number ending in 118. And the remaining will be dismissed, including a not seeking charges on a pending matter. Is that correct?
Correct, Your Honor.
Okay. Mr. Keithley, that's your understanding of the plea offer?
Yes, Your Honor. However, one addition to it, my understanding was that we had reached an agreement pursuant to People v. Killebrew that Mr. Ryan's sentence have a term of no upfront jail at time of sentencing.
That is correct, Your Honor. I apologize.
Okay, so no, Killebrew, no upfront jail, and then no objection to 769.4A has also been noted here. And then for our discussions about this yesterday, if this were to proceed with a plea, the court would dismiss the PA 53. And so, Mr. Ryan, you heard the plea offer that was stated on the record here?
Yes, ma'am.
You want to accept that offer today?
Yes, ma'am.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you, sir. You can put your hand down. Mr. Ryan, you're represented by Mr. Keithley from the Office of the Public Defender. You have the right in each of these files to proceed to a trial. You have the right at the time of trial to have a jury trial, and you have the right to remain silent and not have silence be used to prove or implicate your guilt. You have the right to question or cross-examine any of the witnesses the prosecution intends to call. You have the right to call your own witnesses at trial and present any evidence you believe would further defenses to these charges. You have the right to be presumed innocent at the time of trial until proven guilty. And then you have the right to have each element of the charge be proven beyond a reasonable doubt by the prosecution. If you want to accept the offer and plead guilty to the domestic violence and to the added count of stalking, you have to give up all of those rights. Do you understand that?
Yes, ma'am.
Do you wish to give those rights up today, sir?
Yes, ma'am.
Anybody making any promises to you to get you to waive your rights and plead guilty?
No, ma'am.
Anybody threatening you to get you to waive your rights and plead guilty?
No, ma'am.
Are you currently on probation or on parole?
Yes, ma'am.
Okay, out of which court?
Eaton County.
Okay, have you discussed with your attorney if this would have any impact, a plea here would have any impact on your probation status?
Yes, we have.
Okay, you still wish to waive your rights and plead guilty?
Yes, ma'am.
You understand that a guilty plea in this matter will result in a conviction that you may need to report to your current employer or to a future employer?
Yes, ma'am.
You understand that?
Yes, ma'am.
Okay, it also could have an impact on any immigration status that you may be seeking. Do you understand that?
Yes, ma'am.
Okay, and as to the charge of domestic violence, how do you plead, sir?
Guilty.
And as to the added count 2 of stalking and file number 22-00118, how do you plead?
Guilty.
Have a factual basis, please.
Thank you, Your Honor. Mr. Ryan, on or about 5:30 of 2021, were you in the area of South Pennsylvania and Irvington in the city of Lansing, Ingham County, state of Michigan?
Yes, sir.
On that date and at that time, were you in the presence of a Jacqueline Anderson?
Yes, sir.
And is Ms. Anderson an individual with whom you have children in common?
Yes, sir.
And on that date and at that location, did you in some way commit an assault or an assault and battery upon Ms. Anderson?
Yes, sir.
And is that because you tackled her?
Yes, sir.
And did she give you permission to do so?
No, sir.
And did you have legal authorization or other legal justification for doing so?
No, sir.
Now, after having been charged with the in the domestic violence case, did you, between the dates of 11/12/21 and 11/14/21, did you have contact with Miss Anderson?
Yes, sir.
And she had in some way indicated to you that she didn't want to have contact, right?
Yes, sir.
And you continued to have contact in spite of that, right?
Yes, sir.
And it was not simply one contact, was it?
No, sir.
In fact, you called her several times and or texted her several times, right?
Yes, sir.
And you would not disagree that that conduct would cause a reasonable person to feel frightened, threatened, or harassed, right?
Yes, sir.
And you do not dispute that that conduct did cause Miss Anderson to feel frightened, threatened, or harassed, right?
Yes, sir.
And to the best of your knowledge, was Miss Anderson at or near the area of 817 North Martin Luther King in the city of Lansing, Ingham County, state of Michigan at the time you were contacting her?
Yes, sir.
I have no further questions, Your Honor.
Thank you. Any questions for you, Ms. Lacy?
No, Your Honor, the people are satisfied.
The court is also satisfied with the factual basis. I will accept your plea. Finding your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Prior to sentencing, you need to meet with probation so they can provide the court with a pre-sentence report and recommendation. You're going to be in custody for some time, or are you going to be released soon?
If I'm released from here, I'll be going to Eaton County.
Okay, your sentencing is going to be July 26, 2022 at 8:30 in the morning, okay?
Yes, ma'am.
Do you have any questions for the court today?
No, ma'am.
Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set, sir. You're free to go, Mr. Ryan.
Oh, thank you.
You're welcome. Which matter are you here for?
Morning, Your Honor. We're here on the Stanley Hayes motion.
Okay, Mr. Mattson, can you hear me?
Yeah, you see me, I'm not driving or anything, just so you guys know.
Okay, thank you. On the record in the matter of the people of the state of Michigan versus Vincent Mattson, file number is 22-00976. Council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Vincent Mattson, who is appearing separately by video, Zoom.
For pretrial, the court did receive via mail a request or petition for referral to determine defendant's competency to stand trial. This is based on your interactions with your client, Ms. Donnelly, correct?
Yes, Your Honor.
And also a hearing.
No,
to see
just
if
hold
I-
on. Yeah,
Mr. Mattson?
yeah.
Mr. Mattson,
Uh-huh.
we'll remind you of your right to remain silent. Anything you say can be used against you, okay?
Okay.
Okay, and there's indicated here on the request, information regarding his prior mental health history. And that's what's the basis of the request, correct, Ms. Donnelly?
Your Honor, that is largely what I relied on to base the request. My own observations, as well as it being such a current competency review back in September.
Okay, looks like back in September 2021. Any objection to the petition to have him evaluated, Ms. Lacy?
No, Your Honor.
Based on your request and consistent with the court's previous interactions with Mr. Mattson, I think your request is appropriate, so I'll grant your request and I'll order him to undergo evaluation for competency at the Center of Forensic Psychiatry.
And criminal responsibility, Your Honor. It's also in the request.
Have your order for competency. I don't have one for criminal responsibility.
Oh, I apologize. Your Honor, if you'd allow, I would, I'll pull it up, I'll make sure that it does have it, and I can send, if it needs to, I'll send it over another one here shortly.
Okay, I'll note here, I will grant the request for him to undergo for both competency and criminal responsibility. I do understand that the Forensic Center has not actually been processing our request for criminal responsibility on misdemeanors due to how inundated they are. But we can at least attempt to see.
Thank you.
Okay, any additional matters for the record?
Nothing from the people.
None for defense. Thank you, Your Honor.
Thank you. You're all set for today, Mr. Mattson.
Hey, Vincent, do you, or can I call you after this?
Yeah,
Okay, all right then. Thank you.
you're welcome.
Well, you can be seated, sir. Ms. Lacy,
Yes, Your Honor.
did you submit oh, you did, it's in the file. I was trying to see.
I
if you
did.
Responded to the motion. Okay, thank you.
Yes.
Mr. Hayes, can you hear us?
Yeah.
Perfect.
Yes.
Mr. Hayes, can you take off your hat, please?
Are you talking to me?
Yes, Mr. Hayes, it's your lawyer. Good morning.
I can hardly hear you.
Hearing better now.
Nope.
That's for the recording.
How about now, Mr. Hayes?
You're still low. I can hear you though, but not very loud.
That's probably on it. Can you hear me, sir?
Oh, yes, I can hear you much better.
You can hear me, so. We're on the record in the matter, the people of the state of Michigan versus Stanley Hayes. I found number 22-00286. That's the council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Morning, Your Honor. Brendan Basiga on behalf of Mr. Stanley Hayes. I'm appearing in person. Mr. Hayes, due to mobility issues, is appearing by Zoom.
Thank you. Today's the date that is set for a motion for summary. Are you planning to stand here, sir?
Sorry, Your Honor. If I was trying to figure out where best to stand so that he can hear me and see me.
I don't think that that's gonna impact where he can hear you,
That's fine.
because you're gonna need to be near something for recording purposes, of course. Mr. Hayes, are you struggling to hear your attorney?
I can hear him.
Okay, I have a copy of the defendant's motion to dismiss for illegal search and seizure. There was a response here filed by the people. Mr. Basiga, this is your motion. You may proceed.
Yes, thank you, Your Honor. First and foremost, we must begin with the analysis that a warrantless search and seizure is per se and axiomatically illegal. Now, that being said, we also must proceed from the well-established case that it is for the people to justify a warrantless search or seizure. In this case, Mr. Hayes was pulled over due to a what is alleged to be a broken headlight. At that time, the troopers approached his vehicle, and despite the NHTSA, National Highway Transportation Safety Administration guidelines, needing to wait for 15 minutes to administer a PBT, they administered a PBT to him while he was sitting in the car. My point in all of this, Your Honor, and I'm not trying to belabor the point, considering I have no doubt that the court has already read the motion as well as the brief and the response. My point in all of this, Your Honor, is simply that the troopers exceeded the scope of the actual stop. The stop in and of itself was for a traffic violation, period. That's it. Thus far, no further. It then extended into an OWI investigation. My submission to you, Your Honor, is that it extended into an OWI investigation without probable cause, more importantly, without a search warrant, or, pardon me, without a warrant of any kind. The people want to say that there's exigent circumstances or that it fits under some sort of exception. I fail to see what exception it falls under when the stop in and of itself was for a traffic violation. So we begin with the premise that an illegal, that a warrantless search and especially an illegal seizure is a warrantless seizure is illegal per se. Then next we follow that it is up to the prosecution to prove that there was probable cause to carry forward. Well, in this case, what probable cause is there beyond the fact that he was pulled over for a broken headlight, not taillight, headlight. There's a claim that he had, and I'm just looking for the exact quote here. Bloodshot eyes and slurred speech and some emanation of alcohol coming from his body. I note, Your Honor, that according to the National Highway Transportation Safety Administration, which is, by the way, the governing body that governs OWI investigations, they set the standard for them. They set the standard for what is and is not admissible as far as the field sobriety tests, as well as the investigation process itself. That is 3 out of 12 indicators. That's less than half. Actually, that's 25% of the indicators of what could possibly be, what could possibly lead up to OWI. So I have an issue with several different things with the way that this stop was conducted. Number one, he was stopped for a traffic violation. Number two, I believe that they exceeded the scope of the traffic violation by continuing to interrogate Mr. Hayes based on 3 out of the 12 factors. They improperly administered a PVT. There was no 15-minute waiting period. It was actually found that he had gum in his mouth. Which is the very reason why there's a 15-minute waiting period, in order to ensure that there is nothing that he is consuming, drinking, or other has other medical conditions that would lead to a false positive. Ultimately, the PVT rendered a reading of point, I want to get this right here, Your Honor. I believe it was a 0.10, actually 0.104. He was later taken to the Sparrow Hospital where a blood draw was conducted. That did indicate a blood alcohol content, slightly more than that, the 0.11. So for all intents and purposes, Your Honor, I believe that it is my submission that this was a pretextual stop at the very best, which leads to fruit of the poisonous tree. Therefore, this is an illegal search and seizure. That's the reason why, Your Honor, I'm asking that this case be dismissed.
Okay, I'm gonna be clear. I'm just want to make sure I'm following what your argument or issues are. Your issue is that that they stopped him for a traffic stop
Yes,
and that it materialized into a OWI investigation.
I'm saying that they exceeded the scope of the traffic stop.
Okay. And you're saying that they exceeded the scope based on what?
Well, that's my problem. That's exactly the issue.
Well,
I
if you're
don't-
saying they made, this is what you, the only information I have is what you provided me at this point. You're saying that they made contact with him based on the traffic stop. You're not, your argument is not that there was no reason for a traffic stop, correct?
Correct, Your Honor.
Okay, and then that they made contact, that they noticed bloodshot eyes, that his speech was slurred, and there was some evidence of alcohol, and that was not sufficient to provide probable cause. That's your argument.
I'm saying that's what they're alleging, and I'm saying that that at most rises to the level of reasonable suspicion, not probable cause to conduct a further investigation.
Okay. Ms. Lacy.
Your Honor, I'm not going to waste the court's time. I wrote a very, very lengthy response
You're not
to
wasting
this.
my time. You guys I want you to argue your brief, because all of you, I know you believe that your briefs were clear to follow, but they're not as clear as you, from my reading of that. I would need you to clarify some sections. So I don't want you both to come in here and say, I'm not going to waste the court's time. This is the time set aside for you to make your arguments, and I want you to use that time for this purpose.
Yes, Your Honor. So it appears to me that there is a very blatant or willful ignorance on part of Mr. Basiga regarding the law. For the automobile exception, as I outlined in my brief, there is no mention of this exception in his motion. It's well-established law that does allow police officers to extend a traffic stop based on probable cause. The probable cause or the incidents in which the officers had enumerated for the basis for that probable cause to extend that stop are well within the legal parameters that they are allowed to conduct a traffic stop. If they had stopped Mr. Hayes for anything and realized he had bloodshot, watery eyes, he was not able to, he was slurring his speech, they would be able to conduct this investigation under normal circumstances. This is not something that they did as a pretext stop, as Mr. Basiga had argued. It was clear that this is a safety issue. He was stopped, and then during the stop, the course of that investigation, they determined that there was something else going on. I did outline the test, or I guess the parameters into which the court must determine if that basis for the extending the stop is reasonable. I think under these circumstances, the officers were conducting a traffic stop investigation, and during that, they determined that something additional was going on. I think that in order for them to carry out their job duties effectively, they had no choice but to carry on an OWI investigation because of the things that they had observed on Mr. Hayes.
Well, can I have you specifically respond to his statements? I mean, he is not disputing that there was the justified reason for the actual traffic stop. His dispute is that the statements indicated by the officer, which was that there was bloodshot eyes, slurred speech, etc., that those did not amount, or if there was not enough that amounted to probable cause for a search, but that there was only at best reasonable suspicion. So can you address that, please?
Your Honor, the officers did attempt to do numerous SFSTs. They had asked Mr. Hayes previously if he had any medical conditions under which he would be prevented from performing those. He was able to at least attempt 3, which he failed. And then the other 2, after they had been explained to him, he said that he had a medical condition that would prevent him from doing them. I think at that point, Your Honor, they have no choice because he is present a medical condition. They have to pursue other options, which is why the PBT was administered. I believe he consented to the PBT as well. Now, I know that Mr. Basiga is arguing that it was administered improperly, and I don't disagree with that because originally he should have been observed for 15 minutes prior to administering the PBT to make sure that he did not have anything in his mouth. However, he did get a second PBT, and then later on, he did have a blood draw that confirmed the results of the PBT. So while the first one may not have been to protocol specifically, the additional time with which the second PBT was administered would only serve to lower his blood alcohol content unless it was rising at the time. And even further, the blood draw, again, because it took place later, would only show a lowered blood alcohol content than was originally present at the time of the stop, unless it was, again, rising at that time. I think that they definitely had probable cause. I mean, based on their training and experience, I would assume that they would know whether or not they believe somebody is to be intoxicated, which they did, which is why they carried out these tests, and he was unable to perform them. So they did what they had to do to make sure that it was safe for him and or other people to be on the road at that time. And I think that was reasonable given the circumstances of the stop.
SFTs were performed.
If you give me a second, Your Honor, I will pull up the actual police report.
Did you address what SFTs was performed in your brief?
I did not specifically address them, but I can answer your question.
Well, this is what I mean about the briefs were not as thorough or as you all thought that they were. How are you arguing that there's not enough evidence if you didn't even tell me what was done? I don't know. I didn't watch the videos. You did.
Well,
What SFTs were performed? How did we get there? Did he ask the defendant, was there anything in his mouth? If you're saying there was something in his mouth. I don't know if he asked and the defendant lied. You didn't provide me any of that substance.
actually, Your Honor, that's exactly my point. That is exactly my point.
I don't know if he asked, you didn't put that in there.
If I may,
Mhm.
if I may, Your Honor. My point is that the officers did not do that. The
Did not do
officers
what?
did not ask him, do you have anything in your mouth? Did they wait for a 15-minute period, waiting period, which they did not. They did not ask him, what medical conditions do you have? They brought him out of the car with obvious difficulty. The court has observed Mr. Hayes himself coming in here with a wheelchair. And the field sobriety tests that they attempted to perform were the horizontal gaze nystagmus.
Mhm.
I believe the second one was the one leg stand, but that obviously did not happen because of the fact that Mr. Hayes can barely stand. And I believe the third one was a recitation of an alphabet, which is not included as one of the recognized standard field sobriety tests that lead to the OWI investigation. There are really only three, Your Honor: the one leg stand, the walk and turn, and the horizontal gaze nystagmus.
Okay, so
Oh, and Your Honor, I can tell the court which ones they did perform.
okay, well, I just have to follow up on that question, something that he stated. You said in your brief, officers asked Mr. Hayes to leave the vehicle and to conduct the field sobriety test. They then realized Mr. Hayes was chewing gum and informed him that he would have to take a breathalyzer after at least 15 minutes. And then your statements that they didn't wait the 15 minutes after that?
That's my, yes, Your Honor.
And what is that statement based on? You watched and,
That's
it
based on the videos.
okay. And so how long before they took it, between the time that they asked or they found out that he had something in his mouth before they took the breathalyzer?
Slightly over 10 minutes, Your Honor.
Okay, Ms. Lacy, you wanted to address the SFTs that were performed?
Correct. They did perform the horizontal gaze nystagmus test. They did the lack of conversion test. They could not complete the walk and turn test, and he could not complete the one leg stand.
They attempted the one leg stand and the walk and turn, and they could not because of his condition. Is that what you're stating?
It does appear that way, yes.
Are you disputing that?
No, Your Honor. That's part of my point.
Okay, so they were unable to complete two of the standardized tests due to his medical condition is part of your argument.
Yes.
And so they used another test not listed in the three standardized to try to identify some cues. Is that also your argument?
I believe so. Yes, Your Honor.
Okay, and how did he perform on that one? Ms. Lacy?
Your Honor, for the court, to be completely transparent with the court, I did not have an opportunity to view the video prior to responding to this. Only thing I had to work on was the initial police report because it had expired. I did not get it until the day that this originally was scheduled to be heard. I have not watched it since. I have not had an opportunity to do so. So I cannot tell the court.
The alphabet text.
I don't believe so. No, Your Honor.
Okay.
My notes indicate that he got close, but not quite.
Any additional argument from you, Mr. Basiga?
Just to respond to people's response, not to sound redundant, Your Honor. My submission is that they're, the people are putting the cart before the horse here. They're saying that because they didn't do the PVT properly, then they had to do a blood draw, and the blood draw showed at a 0.111, so a 0.11. And because the 0.11 showed up, that justifies going backwards why they arrested him for OWI in the first place. That's reverse engineering the situation, Your Honor, which simply cannot be done. An investigation must be built upon, forgive me, I use the Mike Nichols analogy of it must be built upon a foundation, which leads to essentially a pyramid. The foundation must be a proper investigation done in the first place. My problem is they did not do a proper investigation in the first place because they did not have reason to. Secondly, they did not administer the PVT properly, which then leads them to go to the hospital to do a blood draw. The blood draw indicates 0.111. But at the same time, we cannot use that to justify the means. So my submission, Your Honor, the people have it backwards. Therefore, I do not believe that this is a proper arrest. I do not believe that this is a proper seizure. I believe it violates Mr. Hayes's Fourth Amendment right, and I ask it to be dismissed.
Okay. Did you also
In your-
at any
Your
time
Honor.
address? Oh, give me just a moment. I'll give you.
Sorry.
A chance, Ms. Lacy. In the people's response, they addressed this consent of your client to search the vehicle, and they also found open alcohol. And do you want to address that? Because why would that not help support probable cause?
Happily, Your Honor, I watched the video. There was no, the bottles that were found were in the back of his car, not in the center console. And they were there, according to my client, for the purposes of taking them back to Kroger for bottle return.
Oh, so you're saying they were empty bottles,
Yes,
and you can return empty bottles of Hennessy to Kroger?
I believe so.
Never knew that you could return alcohol bottles to Kroger.
I'm not sure whether it's Kroger or Costco.
Any.
I've tried.
I don't think, I never knew you can return any alcohol, Hennessy bottles at that to Kroger. But nonetheless, Miss Lacy.
Your Honor, I feel like I need to make a record that nowhere in my argument or my brief am I justifying the blood draw for the arrest. I think the arrest was justified based on the observations of Mr. Hayes having had bloodshot eyes, slurred speech, and he smelled like intoxicants. And then the failure of the SFSTs. The officers, again, were not able to perform some due to his medical conditions, which he failed to disclose originally. And they had to determine whether or not it was safe to let him drive, because at that point, they did not think that it was. The ABC test, if it was administered, I know that used to be common practice. And maybe that's just something that the officer knew off the top of his head to use as an alternative to the ones that Mr. Hayes was unable to perform due to his physical ailments. And again, the preliminary breath test, I'm not saying that the blood draw justifies the arrest, but while the original PVT was not completed, as far as I'm aware, to their standards or to procedure, I don't think that gum in and of itself is going to be enough to alter the results from a 0.00 for someone who already had admitted to drinking to a 0.104 is what I believe it was originally. And then again, like I said, he consented to that PVT, he consented to the blood draw. The blood draw, in fact, as Mr. Basiga states, is actually higher than the PVT was originally. So just shows, at least to me, that his blood alcohol was not at its highest point at that point. So it was still rising at the time. And again, based on the number of OWIs that I have seen and the procedures that are carried out routinely by the police, this was by the book, by all necessary requirements, except for that weird PBT test taking place within 10 minutes of observing him with gum in his mouth.
Okay, Mr. Pasiga, this is still your motion, so I have to give you the last word. And also, you didn't mention anything today about your argument that you placed in your brief about your client's Miranda warnings. And I don't know if you're intentionally abandoning that argument because of the case law provided by the people, or if you want to address that at this time.
No, Your Honor, I think I'm going to focus simply on the arguments that I made here today with regards to the procedural deficiencies. As far as the last word is concerned, Your Honor, I'm not saying that the people's argument is that the blood draw justifies the arrest. What I'm saying is that the arrest must be justified in and of itself before the blood draw takes place. So that's my problem with this whole situation. We're reverse engineering it. And it is my submission, Your Honor, we can't do that. As far as the gum in the mouth, there's a very specific reason why NHTSA has mandated you must observe the individual for 15 minutes. Remember, PBTs and even the evidential breath test at the station, I'm not saying he took one, I'm just using this as an example. These are machines, and by definition, machines have a standard deviation of plus or minus 0.02. I am by no means saying that a piece of gum is going to completely absolve him from triple zeros all the way up to a 0.10. That's not the point. The point is the gum in his mouth will alter the reading of the PBT, up or down. So it therefore becomes unreliable. And in that unreliance, therein lies the failure of the probable cause.
Good, okay, well, the court's heard, reviewed both of your briefs and your motions and briefs. I've heard your argument. I am going to reserve my ruling at this time and issue a written opinion. Any additional matters before we adjourn today?
Nothing for me. Thank you, Your Honor.
Nothing from the people, Your Honor.
Thank you. You're all set for today, Mr. Hayes.
I'm all set for today.
You are all set for today. Thank you.
Thank you, Your Honor. Before I go, I'd like to introduce Mr. Colin Brannigan.
Hi.
New law firm.
Oh, nice to meet you.
Nice to meet you.
Did you guys coordinate your blues on purpose today?
No, that was not intentional.
Okay, well, you're doing good then, I'm sure.
Thank you.
Well, congratulations. Hope you have a good experience this summer. I'm sure you will.
Thank you.
All right, thank you. Mr. Hayes, did you need anything else?
No, I mean,
Okay,
what does this all mean though? I mean, what happens from here?
your attorney will give you a call, okay?
Okay. All right,
Thank you.
thank you.
Thank you, Judge. Thank you, all staff, for helping with Mr. Hayes.
What happened to? Who was that gentleman that came in?
Derek Blakely Smith was sentencing yesterday, he didn't appear.
Oh. Where'd he go?
He's still sitting out
Is
But I
that Mr.
emailed his-
Keithley's?
there. No, Yang. I
Oh,
emailed Mr.
that's
Yang
right.
to have him log in, he hasn't joined.
Okay, who is
Bench warrant also was not entered.
the 10:30? No, because I said I would hold it till the end of the day.
Yeah, so it's just here.
Right. Let's give him a new date, because Mr. Yang could be in court or something. Nicholas Liu. Hello, sir. What's your name? About 24 hours late, aren't you?
Yeah,
What happened?
I was doing a job interview for International Ceramics Trust, and I gotta get a job from my probation for, they told me they were picking me up, so. On top of that, I had to take myself.
It's a good move. good excuse. We'll take it. We're gonna get you a new court date because your attorney is not available, I'm sure, because he hasn't responded to our notice or our message that you were here today. I told him I would hold the bench warrant because you had been at all your other court dates. So it was never entered in lien. We will get you a new court date. You need to make sure, do you have a phone?
Yeah.
You can appear via phone on Zoom, you know that? Just need to have video. Okay, is that a problem?
No.
Because what if you get called for a second interview?
Said you can log in.
No, I didn't know
Oh,
that
he's
my
gonna
phone
log in
was
now.
ringing while I
Yeah,
was
he said, should I do that
I
now?
was in the middle of.
Well, it sounds like
the
Mr. Yang just responded, so he's gonna log in now. You have the phone?
Your Honor,
Yes.
I apologize for interrupting, but would it be possible to handle or address a matter that's or at least I emailed about yesterday?
Yes, which matter?
Your Honor, it's the jury trial set for Tuesday next week. As I indicated in my email to the court staff and Ms. Lacy, I have not had contact with Mr. Keith for some time. To the best of my knowledge, none of my contact information works, and he is currently on bench warrant status for his matter pending in the 30th Circuit Court. What I emailed about yesterday was just requesting that the jury trial date set for Tuesday be converted over to a pretrial. That way we can, one, I'm not really in a position to prepare for a jury trial when I can't get in touch with him. Additionally, we can save the witnesses the inconvenience of coming to court when I believe it is very likely he will not be appearing.
That's no problem. We've already had a final pre-trial on that, so
We have, Your Honor.
we'll call it a final pre-trial on the docket, but we won't require witnesses to appear.
Very good,
Thank
Your
you.
Honor. Thank you.
No problem. Nicholas didn't appear. Mr. Yang?
Good morning, Your Honor.
Good morning. Okay, Mr. Blakely Smith, you can come up here. We're on the record in the matter of the people of the city of Lansing versus Derek Blakely Smith. This is file number 20-02835. Do I have your appearance, counsel?
Joseph Yang on behalf of Mr. Blakey Smith. I'm appearing via Zoom. Mr. Blakey Smith is in person in the courtroom.
Thank you. And today is not the date that was set for sentencing. It was set for sentencing yesterday. Mr. Blakely Smith did not appear. The court held the bench warrant. We did not enter it because Mr. Blakely Smith had been in regular communication with you, Mr. Yang. And so it was unclear to you as to why he would not have appeared. He did let the court know today that he had a job interview. And so that was why he did not appear. So the court will proceed with sentencing at this time. I do have a pre-sentence report and recommendation here. Did you receive a copy of that, Mr. Yang?
Yes, Your Honor. Mr. Blakey Smith and I have reviewed that. There are no additions, corrections, or deletions. The only thing is the supplemental information that I was able to get from the 30th Circuit Court Probation Department with the additional terms that are required for his felony probation. I apologize, for his felony probation with Judge Aquilina. And I did submit that to the court. The court wanted to know exactly what his orders were. And so I was able to reach out to Mr. Ed McQuillan to provide that.
Okay.
And
Okay, I've had an opportunity to review the order of probation from the 30th Circuit Court. Ms. Ina, you can make any additional allocution at this time.
Thank you, Your Honor. Again, I'll just reiterate what I requested last time is just to defer to the 30th Circuit. I know that one of the conditions is that they would defer to 54 as well, because they knew this case was coming up. But he's already been established with 30th. I would ask that the court defer to their supervision, waive as many of the fines and costs as possible, as I do believe he is indigent. Thank you, Your Honor.
Thank you. The court's had an opportunity to review the pre-sentence report, the prior criminal history, and the order of probation for the 30th Circuit Court. Mr. Blakey Smith, you are on probation until April 2023. I don't believe it's meaningful for the court to put you on a term of probation here if you're already on probation there. You're being monitored, and it's obviously being effective because you missed court for the purposes of trying to get employment. And so hopefully you land the job opportunity. But in addition to that, the court does want to make sure that any substance abuse concerns are properly addressed. I don't really see any programming.
Your Honor, under condition 20, I'm sorry, condition 33, 9.20, complete substance abuse currently in that probably, yeah, it should be a substance abuse program. He's with Crystal Ray participating in that program. So
Okay, and you're still participating in that program? Yeah, okay, because it just says complete substance abuse currently in. So if you're you're still in that programming, there's no need for me to add any additional programming. You're obviously testing because that was ordered. You had to comply with the requirements of alcohol testing as directed by field agent. This is not meaningful to put you on probation here. And so at this point in time, I'm going to issue of fines and costs only in order that you remain compliant with your probation before the 30th Circuit Court. A fine is going to be in the amount of $75 crime victim rights fee, which must be assessed. There's a $50 state minimum cost that must be assessed. I'm just looking to see if it was OWI cost recovery because, oh, it is here. Okay, you owe the Lansing Police Department $384.95 for restitution for responding to the incident, okay? Is that a yes? Okay. Okay, so I'll waive any discretionary fines and costs at this time. So you owe a total of $509.95. And I'll refer it to collection so you can make a payment plan with them, okay? What's your phone number, sir?
517-574-8971.
Okay, very good. I will have you make a payment plan with collections and so you can get that taken care of. Do you have any questions? Any additional matters for the record?
nothing further, Your Honor. Thank you.
You're all set, sir, and good luck. Let's see. Carrington's at 1:30. Okay, that's all we have. I think that's all we have, Miss Lacy.